Right, and you have the other one. Yep.
Is she ready? Is she ready in the back? Okay. All right, let's get this on the road. Good afternoon, everyone, and welcome to the City of Millville. Agenda for hearing of an appeal made to the Board of Commissioners concerning approved D variance for Liberty Village, the third in Block 52, lots 88, 89, 90.01, 90.02, and 90 on September 21st, 2021 at 4 p.m.
That was wrong.
Actually, it's today, 10/5.
Sorry.
I'll correct that. Thank you, Jeannie. 10/5/21 at 4 p.m. I call this meeting to order. Roll call, please.
Commissioner Pepitone.
Here.
Vice Mayor Parent.
Here.
Commissioner Udalvis. Here. Commissioner Cooper.
Here.
Mayor Santiago.
Here.
Okay, motion.
This meeting is being conducted in accordance with the Public Meeting Act of 1975, was advertised, posted, and made available to the public as required by statute. The municipal clerk is directed to include a statement in the minutes of this meeting. Now, I hear a legal argument to be given by appellates Charles Hewitt and Lisa Orndar.
Mr. Mayor, if we may.
Go ahead, sir.
A few ground rules. This is considered a hearing de novo on the record. The record consists of the transcript. It also consists of the items of evidence that were introduced into the record by the applicant at the hearing, which I believe took place on July the 1st, if I'm not mistaken. So the order of proceeding would be that the appellant would go first with legal argument or argument they want to make. No testimony, no evidence. The evidence, again, is what's contained in the record. Then the developer can then make whatever legal argument he wants to make. Again, he cannot introduce new evidence into the record. The statute also provides that if an interested party requests a copy of the decision, they're entitled to notice, and I assume they would be entitled to be heard. There was an attorney that contacted my office. I don't know if he's present tonight, but I understand he did request a copy of the decision, and so it would be my view that he also would be entitled to be heard. I have no idea what position he would take. I think he may represent someone that owns property in the area. Now, prior to proceeding on the merits, the Board of Commissioners did receive a letter directed to us by the applicant's attorney, Matthew Robinson, requesting, I believe, a 60-day adjournment. So he also indicated in his letter that he was waiving the 95-day period, which is part of the statute. We would have to conduct this hearing within 95 days of the, and I believe it's the publication of the notice of decision. If we don't hear it within 95 days, then it would be, the appeal would be, or the ability to hear the appeal, I think, would be lost, unless the rules provide the applicant, the original applicant to the board, agrees in writing to waive the 95-day rule. So I think the first order of business would be for the Board of Commissioners to decide whether or not to grant that request for an adjournment. And maybe Mr. Robinson can speak to that as to what he's seeking, how long he's seeking it, and what the reason is, and then we can proceed from there.
Thank you, Mr. Solicitor. Mr. Robinson, please identify yourself.
City Commission, Matthew Robinson. I'm the attorney on behalf of the underlying applicant that was heard before the Millville Zoning Board of Adjustment, Frank Carpino. Mr. Solicitor, was my adjournment letter distributed? Did everyone have a chance to see that letter? It was short and sweet, it was one page. The essence of the letter was that under municipal land use law, this is a very peculiar appeal structure. You don't see many of these. I've been doing this for a decade, and I haven't run into one of these before for municipal appeal to be heard before the City Commission. The transcript is supposed to be ordered and circulated. I received the transcript only a few days ago. It's 300 pages total for the record.
Can you speak into the mic a little bit more? Excuse me. Thank you.
Sure. Upon receiving the transcript and all of the other exhibits that were presented,
Sorry.
I requested immediately. Maybe it's not on. Hello?
Hey, we can hear you.
Thank you.
There you go. I immediately contacted the solicitor to notify him that I just received this 300-page document. In the interest of justice, I'd like to meet with my client, all of the 4 expert witnesses who testified that night. We had fact witnesses who testified that night. I wanted to review the transcript with all of them, make sure as to the accuracy, the contents of that transcript, so that I could be fully prepared for my client's rights today. So upon just receiving this large dump of the transcript, that was the basis for the adjournment request, so we could have a fair and thorough appeal hearing this evening. So I renew that request now before the City Commission. I think it's in the best interest for all of us to be well prepared. If the city has had a chance to review all 300 pages, and I was just the last one, unfortunately, to get a copy of everything, I understand, but I wanted to make sure that we go on the record and everyone has all of the exhibits, all of the transcripts, everything, and it's been thoroughly reviewed. If not, I'm electing, per the statute that the solicitor noted, to waive the 95-day requirement, because I'd rather have it be a duly, fairly decided appeal rather than a rushed appeal. So I'm waiving that right, and that's what I'd ask from the board.
Mr. Robinson, how long of an adjournment are you seeking?
I put 60 days into the notice because if I'm going to have 5 people review 300 pages of materials, I didn't want to do the ultimate sin here, which was ask for 30 days and come back and ask for 30 more and do this all over again. I won one single adjournment request. I will not be making a second request so that we can come back and be fully prepared. Given the scope of the hearing, this was a 4 to 5 hour zoning board hearing. It was a marathon hearing. I think that would be sufficient so that everyone can be fully prepared and no appeal rights are being extinguished. Everyone still has their full time, their full appeal, and their ability to be heard.
And Mr. Mayor, I would recommend you give the appellant an opportunity to respond to the adjournment request, and then he can indicate whether he consents to it or he objects to it. And I think that would be Mr. Hewitt.
Thank you, Mr. Solicitor.
Thank you, Mayor and Commission. As far as the
Mr. Hewitt,
transcript,
for the record, we know who you are, but can you establish that on the mic,
Charles
please?
Hewitt, 2426 Cedar Street, Millville, New Jersey.
Thank you.
And, Mr. Hewitt, you are one of the 2 people that filed the appeal.
Yes,
Is
I
that
am.
correct?
Yes. As far as the availability of the transcript, I've had the transcript in my hand for over 40 days. I knew to come to City Hall and request it. I believe that every one of you have had it in your hands for the same amount of time. Now, I'm no attorney, but I did my job. I ordered the transcript. I've been billed for the transcript. The attorney has people that work for him. They should have at least made an attempt to come to City Hall to receive this. I do object to the fact of postponing this, and if he would like to appeal any decisions made here tonight, he's more than welcome to do that in a court of law. I respectfully request that you vote in whole to carry tonight's appeal on. Thank you.
You're welcome.
And I think there's one other appellant, and that would be, I believe, Ms. Orndorff. And can you state your name and information for the record, please, and confirm that you are one of the appellants?
Yes, my name is Lisa Ordorf, 9 Jenny Drive, Millville, New Jersey, and I am the other appellant for the case. So, understand that we all have had the,
Yeah.
sorry, can you hear me now? We've all had the transcript in our hands for over 45 days. I believe that the transcript was subject to request of an Oprah, so this should have been made, aware to Mr. Robinson, and he should have had access to that. I think both me and Mr. Hewitt are well prepared to, show you folks the case and, go over everything. So I don't think that we need to extend that, as hopefully you guys have been able to review everything as well, and hear us out today.
Thank you.
So I really think at this point, the board needs to vote as to whether or not to grant the request. So there probably should be a motion to grant the request. Then a yes vote would be yes, I want to grant the request. A no vote would be no, I object to the request.
If we move in that direction, what are we looking at? Another 95 days to be prepared? Or what would the time limit possibly be that council could get back so that we can try to get this done with? I mean, what are we talking about, as days?
Well, it
weeks?
sounds like he's asked for a 60-day adjournment. So that would put us at one of the, maybe the first meeting in December. I would think that would be 60 days.
That's correct, Mr. Commissioner.
Thank you, Councilor.
Jeannie, can you read
Okay,
what we would be voting to? Do you
Yeah,
have something?
what was the time element that, I know I received my transcript on a timely basis and had read it all. I also listened in on the meeting that was held by the zoning board. So I don't know when the council actually received that from our clerk. Was it a misunderstanding that
Well,
he did not receive it, or?
The statute is very vague, and it literally only requires that there be one transcript. But obviously, that's not very practical because you need 5 of them, at least so all 5 of you have a transcript to review. But it really doesn't contain any rules as to serving copies of the transcript on the other interested parties. Now, I know that council points to another section of Chapter 30 that talks about the service of transcripts, but I read that as only applying to a land use or a zoning board. If the zoning board is conducting a hearing, the rules for serving transcripts, same with the planning board, but it really doesn't pertain to this application before the Board of Commissioners. So now I will say this, I think that Mr. Robinson did receive, and we wanted to make sure that all the interested parties did have a transcript, and he did receive one according to his letter, I believe on September the 28th. I'm reading from his letter. Certainly, he and his client were present on July 1st, so they would have known what happened at that hearing. And actually, I've been provided with a return receipt card by the clerk, and it looks as if the transcript was received by Mr. Robinson's office on September the 27th.
My question then continues because I've read the transcript, and I think we're going to get redundant on the questions that any of us might have. I'm not speaking on behalf of the commissioners in any way, shape, or form, but I'm prepared myself to get this thing done as soon as we can. I think it is important in some fashion that we reach a decision, whether, I'm prepared to move on personally. That's, that's the way I feel.
Mr. Robinson, you have a comment?
I have nothing further to add, aside from solicitor and I read through the same provision, but the appellant is typically responsible. It's their transcript, they order it, they circulate it. They're supposed to circulate it to the zoning board solicitor, who I spoke 2 weeks ago, never got it. I never got it. So they've had it and they've held it, the appellant's obligation is to circulate it. That's the spirit of all appeal. And I'm referring to municipal land use law reference that I have now. So it just puts the objector, the zoning board solicitor, and the zoning board at a disadvantage. None of them had it. The appellants had it the whole time, and evidently
Right.
the city had it too. So I just want to be on a level playing field.
I understand that, and, you know, but again, you know, if, I don't think there's going to be anything different that what I read that would be asked this evening by anyone, you know, unless one of the commissioners have something.
Is this the time to make
they
comments,
wish
Mayor?
to say, but, you know.
Joe?
Yes, I'd like to make a comment. Mr. Robinson, you had shared that you just received this information approximately a week ago. This information was presented by your group to the board, so it's your information. You did have a week, and it being as important it is to the city, I think that should have been top priority for you guys to review the information. I'm in agreement with Vice Mayor Parent that I think personally we need to move on this.
Thank you, Commissioner. Any other commissioner wants to make comment?
Yes, Mr. Mayor. I had spoken upon receiving the adjournment request via email yesterday to the city solicitor, Brock Russell, and he had advised that it was very much at the discretion of the Board of Commissioners as to whether to proceed. I did ask regarding legal implications, and Mr. Russell, if I may defer to you just to provide the response that you had provided regarding the ability of the board to act on this decision this evening and to hear this once again.
Yes, because the original 95-day period will expire in a couple of days. So this was the last meeting that we could conduct this hearing. That's one of the reasons why it was scheduled today. However, the law does allow, and I'm talking about the municipal land use law, does allow the applicant, and that's the person that filed the application, to waive the 95-day period, and they have to do so in writing, which they've done. So what that means is if this were to be postponed, we wouldn't lose the right to hear this. But you still have to decide whether you want to exercise your discretion and postpone it or whether you want to hear it tonight. That's your call.
Mr. Hewitt?
Thank you. Evidently, there was an email circulated. I, as the appellant, Lisa is the appellant, we weren't aware of this request to cancel. I can't help it that the attorney failed to do his job. And like I said when I was here earlier, at least reach out to the city, because we have all had this in our hands, all the commissioners and myself. This is the first time I'm hearing that I was responsible to circulate this. As far as I know, I was responsible to make notice of appeal, to pay a deposit, and to pay for the transcript. I did everything. It's not my job to have somebody follow up on everything. We're supposed to be hearing the evidence that was heard and presented, and nothing else. I am prepared, Lisa is prepared to go on today. Thank you.
You're welcome. Anyone else?
Mr. Mayor,
Yes.
I understand what the parties are saying. However, it seems to be that there's some discrepancy in how it was distributed. So I believe it is our responsibility as commissioners to always project the avenue of fairness. And it doesn't seem fair that there's a mix-up here. So there's a timeline that we understand. There's one that Mr. Robinson understands, and he's saying to us and appealing to us that he did not have time, nor his client had time, to go over the transcript. I just don't see that it would be fair at this time to proceed knowing that. Are we providing the avenue of fairness if we do that as commissioners? Whether we want it or not, however we vote, it still would be that umbrella of, well, you know what, the commissioner still really didn't provide the avenue of fairness that was projected by Mr. Robinson, and they blew that off. Now, if it's going to be adjourned till the next moment where legally we can do it within the process of the days, I'm sure that Mr. Robinson can expound more on that. If we can do that then and the conversation is the same, let it be. But if we don't provide this avenue of fairness now, how do we look as a commission? Do we look like we really?
Hold on. Vice
My
Mayor.
feeling is how we look as commissioners is we're elected to do something and do something whenever, as soon as possible on this.
I agree.
when
I agree
there's-
with you. But at the same time, if the shoe was on the other foot, would we want the same advantage to be able to go over the transcripts as well? We wouldn't want that same advantage. And it seems like right now that it's not being provided. Whether we don't know when he received it, when he did not, when we received it, there seems to be a discrepancy there. And so if we say, okay, well, you know what, yeah, I know you have an understanding of when you received it, and we have a difference, there's a difference there. We're not all on the same page. So if we make this decision to move forward or not to move forward, it's just not on equal ground.
Now, that's the,
I haven't been in a court of law for a long while, and I don't pretend to be a lawyer, and I don't act like I'm self-appointed lawyer or self-ordained lawyer. But I would sure heck, I don't know what will change from the meeting we're having tonight on the issues at hand that were discussed back at the zoning board meeting.
Get the mic.
I don't
Zoning
disagree
board
with you.
meeting that the discussion was made. I mean, there was testimony from both sides. You know, I think the people, I don't know if anybody in the audience was there. I know some of you were, anyway, but, you know, what will change were the questions and the answers of legal counsel. I mean, I don't think anything will change. I think Mr. Hewitt's prepared for his portion of it. I'm prepared. I read everything. Like I say, I'm not a self-appointed lawyer, but, you know, I can read. What's in there.
I don't disagree with you, Vice Mayor.
you know,
I'm
I
prepared
would
as
sure
well, but I
like
just
to
don't think that it's
Get some
providing the
things
right
moving.
environment.
Mr. Mayor, I have the floor. Thank you.
go ahead, Vice Mayor.
I think that what we should be doing is looking at it, get further discussion on it. If the commissioners are ready to move on it, I have some questions I want to ask. They're not going to change from now or 90 days or 85 days from now. They're the same questions that I have. They will not change. So, you know, if everybody wants to go home, you can go home if we're not moving on it. But, you know, that's my opinion. I'm here because I want to listen to what's happening, and I'm here because I want to make a decision.
Thank you, Vice Mayor. Commissioner Cooper, you have something additional?
I have nothing further.
Okay,
Mr. Mayor, if I may also,
go ahead.
I also realize that in addition to having received the adjournment request just yesterday, having received the email, that we were also previously scheduled to have heard this during or prior to our second meeting in February of the commission. So with that in mind and having already postponed this hearing once, I do feel that it's the duty of this commission to make decisions this evening based on all of the information that we have before us, that we've been duly prepared to ask questions about and also to present our findings from the transcripts. And I do feel that that is our role as a commission. I feel it's my role as a commissioner as I sit here this evening as well.
And unfortunately, for everybody here, you know, it's a decision that we have to make individually. And we have to go by what facts are being provided to us. And I think the facts have stated that, Mr. Robinson, you did receive them on the 27th. I just read that. Today is the 5th. I understand it's only a few days or weeks later. But fact of the matter, I think the commissioner made a great point that we were to hear this back in February. So, Madam
Actually, it
Clerk.
was September 21.
September?
September 21 is when it was scheduled.
All right, September 21. Madam Clerk, can we move on, please?
So I guess we would just need a motion someone would need to make a motion.
Do we need a motion to
I would
continue?
do it, it would be a motion to grant the continuance. And that way, yes would be yes, I want to grant the continuance, no would be no, I don't want to grant the continuance.
Okay, so the motion should be on the floor to continue the hearing this evening, is that correct? I'll make the motion, Mr. Mayor.
Second the motion.
So we have a first and a second. Are there
This
any
is- this
comments
is-
additionally?
No, this is can you clarify, this is to
This
allow?
is to grant the request for a 60-day postponement or continuance.
Yeah, I think there was confusion there. Grant 60-day.
Wait, hold on, Brock.
Right.
Say that again.
This
I don't
is-
think
Right,
I don't think
they were
Vice
on the
Mayor,
same
just,
page.
No.
I don't think we're on the same level here.
Right.
Vice Mayor, repeat.
My motion is for us to continue the hearing this evening. That's
Oh,
my
you're
motion.
saying you want to
That's a different
proceed?
motion.
Right.
Okay.
That's correct.
Yes.
Okay, well
Thank
then,
you.
To proceed with it.
okay, you want to proceed, so a yes vote would be we proceed tonight.
That's
A no vote would be no, we postpone it for the 60-day request.
That's correct. Thank you.
That's the way I understood it, too.
Okay, so
The
this is,
solicitor, don't we have to answer Mr. Robinson's motion to adjourn first?
That's what we're doing.
Would you
We're-
change the motion?
My motion was clear for us to
He doesn't make
continue
the
the
motion.
hearing this evening.
Yeah. What the vice mayor is saying, I think, is to deny the
That's correct.
request for adjournment and proceed tonight. So it'd
That's
be a
correct.
motion to deny the adjournment and proceed tonight. So yes would be, we have the hearing tonight. No would be, no, we don't want to have the hearing tonight. We want to have it heard 60 days in
The
the
yes,
future.
the yes vote would be to have the proceeding continue this evening.
Point of order.
Now, he can't, I don't know where he's coming from.
And I'm sorry to do point of order, I presume point of order is okay for Robert's rules here.
it's a hearing, ma'am.
Procedurally, I think that there's a loophole because there's a motion on the floor that is presented already outside of council to do a continuance. And if you change, and I believe this is Mr. Cooper's point, is if you word the motion differently, whether to proceed or not, I believe that would be better to retract that motion and reformulate the motion to order. And that's why I think legally, I feel compelled to speak, so there's no loophole where this gets in some convoluted legal mess.
Yeah, what I like is, just generally speaking, I think I would agree with him. I like a motion to be, there is a request for an adjournment. That's an
That's on the
affirmative
floor now.
request for adjournment. So I think the motion should be styled as a motion to grant that request. So yes would be, yes, I want to grant the request and have it heard on another day. No would be, no, I don't want to grant the request. I think that's clearer, with all due respect, than the way you
Okay.
phrased it.
So a no vote would mean we continue this evening. Is that
If I
correct?
may, just to make
No.
this very clear, I know that when the motion was made, it was a motion for continuance.
Yeah.
And I know that it was misinterpreted as a motion to continue on with this hearing.
Yes.
Madam Clerk, I know that you have language that's already in our record currently about a motion of continuance. Should we vote that down if we plan on not granting
We
the
have a motion
adjournment?
in a second, so we really have to take
So
a
we
roll
should,
on this.
so therefore, I will be voting no to this, to continue on with the hearing this evening. So I just want to make that clear for our commissioners who are here. We've already made the motion, and I understand it was mistakenly made because the word was continuance, and you were thinking it was to continue on, but it was really for an adjournment. So to make it very clean, to make the record very clean, and also, Mr. Myers, I know that you had mentioned that. I think that that would be something that we would just also want to make into the record, is that
Make two motions.
this
You're
evening.
saying make two motions.
You made two motion. Yeah, you'll want to make a second motion. This motion, if you are planning to not grant the adjournment and to continue on with this meeting, you will vote
No.
no. If I can, for clarity's sake, Mr. Solicitor, just to,
As long as everybody understands that.
Okay.
First,
Depends who's on
Yeah,
first.
I know.
Hold on a second.
Point of order, Mr. Mayor.
Go ahead.
There have been several motions that have been proposed. I believe there's one still on the table.
Correct.
Because everyone is confused, can I recommend that any motion that's on the table be rescinded first and then start fresh with a new motion so the public can actually have an idea what's going on here?
yes.
You mean the
Yeah,
public
well-
doesn't know what's going on?
Yeah.
No, it was two motions on the floor.
Yeah,
All right, so hold on a second.
Why don't we
Hold
have
on, Commission, hold on. All right, thank you.
Why don't we have a motion to rescind all the motions on the floor?
I will make a motion to rescind all motions on the floor.
Second the motion.
Got a second from Commissioner Cooper.
We'll start over.
And then we're going to do a roll call.
Roll call, please.
A yes vote would be.
Commissioner
to-
Pepitone,
Yes.
this is to rescind
Yes.
all motions on the floor.
Yes.
Vice Mayor Parent.
Yes.
Commissioner Udalvis.
Yes on a motion to rescind.
Commissioner Cooper.
Yes.
Mayor Santiago.
Yes.
Okay. Motion carries to rescind all motions on the floor. Thank
Now,
you.
if I may, I'd like to propose a motion. Someone's going to have to make it if you agree with me.
Right.
I think it should be a motion to grant applicant's request for an adjournment.
I'd like to make that
Everybody
motion.
understand
Same
that?
scope, right, as in the same scope as the original motion, so.
Yeah, it's
I
a
would be fine
motion
with
to
that.
grant applicant's request for an adjournment.
I'll make that
That's Mr.
motion.
Robinson's request.
Second
Which
motion.
one is the applicant on this?
The applicant is
Mr.
Matt
Robinson,
Robinson's
Right?
client.
So
Yeah.
we know what we're doing, all right. Who's on first, who's on second? We can go back into
Yeah.
that one as we go on.
So a motion to grant the applicant Liberty Village 3's request for an adjournment.
I'll make that motion. We need a second.
Second motion.
Get a first and a second. Roll call.
To adjourn.
Commissioner Pepitone?
I want to make sure that I make this
This
correct.
is a motion to grant.
My no vote would mean that we're going to hear it tonight.
Yes.
Correct.
No.
No,
Vice Mayor Parent?
no,
Commissioner Udalvis?
No.
Commissioner Cooper?
Yes.
And Mayor Santiago?
No.
Okay, so this motion fails.
The motion failed, then I would say that the appellant would proceed with its arguments.
Good evening. If I could, I'd like to give each one of you a copy of our appeal.
Sure. Just hand it right to the solicitor and it'll go right around, please. That's enough.
Do you want-
Whenever you're ready,
do
Mr.
you
Hewitt.
want my
Thank you.
phone? I can have one of the girls make them.
Mr. Mayor, Commissioners, good afternoon. Charles Kirk Hewitt, 2426 Cedar Street, Millville, New Jersey. Zoning laws divide land within the municipality into zones and prescribe the land use and the intensity of development allowed within each zone. Zoning laws require land is used in accordance with a well-considered plan that makes sure the public welfare is served by land use regulations. MLUL 40:55D-70. In 2017, Millville redid its use plan. That was done with the help from the state of New Jersey and input from the citizens of Millville. The City Commission approved this plan. This plan tells the intent and purpose and zoning and land use regulation recommendations for each district. The land use plan shows the existing and proposed location, extent and intensity of development of land to be used in the future. It also includes a statement of the standards of population density and development intensity recommended for the municipality. The comprehensive plan creates a blueprint for the future, for future development and preservation of a community. It is the policy foundation upon which communities are built. A good comprehensive plan guides not only the physical and economic development of the municipality, but also accommodates social, environmental, and regional concerns. If the proposed use of a property does not conform to applicable zoning restrictions, which should be based on the land use plan, the land use can be authorized by a use variance awarded by the zoning board. A use variance permits the use of land otherwise restricted by zoning regulations. Property owners are awarded variances from the strict application of the zoning law, Section 70D of the New Jersey Municipal Land Use Law. actually recognizes 6 different types of use variances. They include variances to allow the following. 1, use of property or a principal structure not permitted in the zone district. 2, expansion of a pre-existing non-conforming use. 3, use of property or a principal structure that deviates from a standard listed in an ordinance that authorizes conditional uses. Expansion or enlargement of a structure in excess of the permitted floor area ratio. Number 5, increase in the permitted density beyond the maximum density allowed. And number 6, construction of a principal structure that exceeds the maximum permitted by more than 10 feet or more than 10%. A municipality's zoning board decides one of any of these 6 use variances. In order to secure approval of the variance, an applicant must prove his entitlement to the specific use variance requested. While the burden of proof varies among the 6 types of use variances, the board's focus is ultimately upon the applicant's ability to address the positive and negative criteria of the variance. Regardless of the type of use variance sought, an applicant always has the burden of proving that the relief can be granted without substantial detriment to the public good and will not substantially impair the intent and purpose of the land use plan. Use variances should very rarely be granted, as granting them does not give proper respect to the zoning ordinance and sets a bad precedent for other decisions. Granting a D variance can do more damage to a municipality, so it is a big deal for the zoning board to grant one. The board must make sure that any development does not affect surrounding properties negatively, and that the community develops in an orderly and cost-effective fashion. Granting the variance should not alter the essential character of the neighborhood. The proposed development should be compared to the existing and permitted uses in the neighborhood according to the land use plan. The decision being appealed here tonight is in regards to the zoning board granting a D1 variance, which is the use of property or a principal structure not permitted in a zone district. However, this project also asked for a D5 variance to increase the density on the property due to the number of units they wish to build. In reaching their decision, the zoning board failed to consider the negative criteria, which far outweigh any valid positive criteria. It also could be argued that a variance for the structure size that is being put on the individual lots in this development is also needed. The small size lots will have to accommodate a mobile home and a garage, not leaving the usual amount of green space and setbacks that other properties in the city have to obey. This is a D3 variance. As a matter of fact, the expert witnesses for the development switched to a discussion of a D3 variance. In the middle of their presentation. That is in the transcript on page 72. The board's attorney in the resolution states there are components of a D3 variance. This would be on the zoning board's resolution, page 12. Neither the board nor the board's attorney discussed this. This leads to the question, did the developer argue their actual case for the D1 and D5 variance or for a completely different variance? Did the board realize that what they were voting on? Was the board properly advised by their attorney? The expert witness for the developer, transcript page 63 and 64, and resolution page 6, the developer's attorney, this is on transcript page 10, and the zoning board attorney and the city's consultants, CME, all did not have the correct zones for the location of the project. The zones were mistakenly called Agricultural Conservation, Airport Industrial District, and Air Park Industry. The actual zones are medium density, residential, and airport enterprise per the 2017 land use plan. Therefore, the entire application could be in error. The developer's expert witness stated that land use takes precedence. Transcript, page 216. To grant a D1 variance, there has to be an understanding of particular suitability, which requires the applicant to demonstrate this particular property as developed for the proposed use serves the general welfare, because the particular property location was peculiarly fitted for the use. How could suitability of this project be discussed if all involved did not even understand the land use plan? The developer himself stated that he looked at no other sites. Transcript page 128. According to the 2017 land use plan, quote, mobile home parks should be in the multifamily residential zone, stating Millville has several apartment and mobile home communities within its border. This land use category was identified in the 2005 land use plan element and continues to warrant a separate land use category in this current land use plan element. The intent and purpose, vision, for this zone is that the city intends to continue its commitment to allow a diversity of housing types and sizes throughout the community. An array of multifamily housing options should be accommodated in areas that are close to civic, retail, and employment centers. This land use category should contain properties that are designated as future affordable housing sites consistent with any future housing element and fair share plan. The zoning and land use regulation recommendation are that existing apartment buildings, apartment complexes, mobile home parks, and trailer courts should continue to be permitted and expanded. This land use category could stand alone as unique zoning district or to be incorporated in the residential or commercial zoning districts where they are currently located, end quote. The statement that there is no mention of mobile home parks in land use plan is false. That was made in the transcript on page 71. Demonstrating that a property is particularly suitable for use is an inquiry as to whether the property is particularly suited for the proposed use. In the sense that it is especially well suited for the use, and in spite of the fact that the use is not permitted in a zone from the 2017 land use plan, the property is not suited for the applicant's proposed use. According to the 2017 land use plan, the airport enterprise zone intent and purpose, vision, is to support, quote, support the airport and related aviation, transportation, and manufacturing establishments. These uses should continue to be permitted, and if expansion is necessary, zoning policy should be permissive and supportive. Zoning and land use regulation recommendations should be that the airport enterprise district should allow for the airport and associated uses such as aviation support and development, technology development, industrial parks, recreational uses, research and development, retail sales, and tourist attractions. Expansion of these uses should be permitted and encouraged to continue the economic viability of this area. End quote. It is inherently obvious the project does not support the airport. In the 2017 land use plan, medium-density residential is composed of single-family detached housing units. The intent and purpose, the vision, is, quote, the desired development pattern in the medium-density residential land use category is single-family detached housing units on 1/4 to 1/2 acre lots. Future development should be geared primarily towards auto-dependent single-family residents. The zoning and land use regulation recommendations are that in an effort to simplify zoning districts and land use regulations, residential neighborhoods with comparable densities and similar usage should be merged into a single medium-density residential zoning district. In addition to residential uses, parks, schools, and other civic uses should be permitted. End quote. It is inherently obvious this project is not a medium-density residential project. Excuse me. For a zoning board of appeals to grant a variance, it must find that the benefits to the applicant of the requested variance or positive criteria outweigh the detriment it will cause to the health, safety, and welfare of the neighborhood, or the negative criteria. Will an undesirable change be produced in the character of the neighborhood, or a detriment to nearby properties be created by granting the variance? Will the proposed variance have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district? Putting a mobile home park in this area will substantially change the character and the quality of the neighborhood and be detrimental to the other single-family homes in the area. This development calls for 332 mobile homes. If the property was developed for single-family homes on 1/4 to 1/2 acre lots in the area zoned medium density, half of the property in question, only 75 to 151 homes would be built, maintaining the character of the neighborhood. This would also greatly reduce the adverse effects and impact on the physical and environmental conditions in that zone, such as drainage problems and traffic. As stated, where an applicant would like to introduce a use that is not permitted within a particular zone, that applicant is required to obtain a use variance, a very difficult variance to secure. The municipal land use law authorizes local zoning boards to grant a use variance where, number one, special reasons exist for the variance, the positive criteria. Number two, the variance can be granted without substantial detriment to the public good and will not substantially impair the intent and purposes of the zone plan and zoning ordinance. The negative criteria. According to NJSA 40:55D70, this project impairs the intent and purpose of the zone plan, otherwise known as the land use plan. An individual seeking A D1 variance could satisfy the positive criteria by showing that there are special reasons why the use is particularly suited for the property. There are some uses that have been deemed inherently beneficial, which means that they are universally considered to be of such value that they fundamentally serve the public good and promote the general welfare. Such uses include schools, hospitals, and group homes. This project is not inherently beneficial to society. This development is not inherently beneficial, but for argument's sake, the New Jersey Supreme Court created a 4-part balancing test that the zoning board must engage in with respect to evaluating compliance with negative criteria for inherently beneficial uses. This test requires that the board evaluate the public interest served by the inherently beneficial use. The public interest is not served by this project. The developer's case is based on erroneous information. The planner, developer, and experts did not look at the intent and purpose of the 2017 land use plan. This development does not comply with the plan for zones and the long-range development of the city of Millville. Number 2, identify any adverse consequences of granting the variance. There were no adverse consequences listed in the resolution prepared by the zoning board's attorney, nor were they presented by the applicant. The adverse effects are numerous. However, the most important adverse consequence is the fact that the development does not follow the land use plan. This area is zoned to complement the airport and for single-family homes on larger lot sizes. Other adverse consequences are the effect on adjacent property owners, in that the character of that area would be greatly changed. Furthermore, the development will cause health and safety concerns due to the increased burden on police, on fire, and EMS, and the schools. The planning consultants for the city of Millville actually advised the board to consider traffic and circulation, environmental impacts, and impacts on community character. The board did not. An example would be Meridian Quality Care versus Wall Township, New Jersey Board of Adjusters. At the time of the preliminary review, the board is under an obligation to deal with matters vital to public health and welfare, such as stormwater management and drainage, sewer disposal, water supply, and traffic circulation. Reference, Deanna versus Washington Township Planning Board. Number 3, consider conditions which might be imposed to mitigate any adverse consequences. This development does not follow the land use plan for the overall vision of the city of Millville. Therefore, there is no way to mitigate the adverse consequences. Finally, balance the public interest in granting the variance versus the adverse impact, as lessened by any conditions imposed by the board, and determine whether on balance there would be a substantial detriment to the public good if the variance were granted. Even if we concede there are any benefits for this development, the detriment to the public good far outweighs the benefit. The zoning board did not consider the detriments of this project. This time I'll hand off to Lisa, and she will finish.
Thank you, Mr. Hewitt.
Again, state your name for the record and identify yourself as one of the objectors.
My name is Lisa Orndorff, and I am the appellant with Kirk Hewitt. The first factor in the 4-part balancing test described above requires a determination of just how beneficial the beneficial use is. The courts have determined that there is a hierarchy among beneficial uses that the zoning board must take into account in applying the balancing test. The more important the use is to the community, the more benefit the project gives to the community. This project was presented as affordable housing, and one zoning board member based his vote on this. However, at no time did the applicant demonstrate any of the requirements of affordable housing were met. Millville has met its affordable housing goals according to the state. Even so, this is still not affordable housing. Affordable housing is generally defined as housing on which the occupant is paying no more than 30% of gross income for their housing costs, including utilities. In the United States, a commonly accepted guideline for housing affordability is a housing cost, including utilities, that does not exceed 30% of a household's gross income. In Cumberland County, the median household income is $50,787. Affordable housing is for people with low and moderate incomes. Low income is defined as at or 50% of median family income, $25,393.50. Moderate income is over 50%, $25,393.50 to $40,629.60, but no more than 80% of the median family income. Spending the 30% of their income for affordable housing, a low-income family should only spend $7,618.05 a year, and a moderate low-income family, $7,618.05 to $12,188.88 per year. The developer stated that the mobile homes would cost between $110,000 to $160,000. Using a mobile home valued at $130,000 as an example, there is a down payment required from 3 to 20%. That is $3,900 to $26,000. Also, as the individuals in this development would not own the land, it is harder to get a loan for the amount needed to purchase. The cap on these loans is substantially less than the purchase price, causing a higher down payment. VA loans are not available. Higher credit scores are also necessary. Most banks charge higher interest rates on mobile homes versus conventional homes. So payments would be more than conventional housing, There's a monthly fee of $620 for this development instead of paying property taxes, water, and sewer. That is $7,440 a year without the mortgage, which on a $130,000 mobile home at 5% for 30 years would be $697.87 per month, or $8,474.44 a year. So the mortgage and the maintenance fees are over the moderate low income marked before utilities are considered. As a side note, taxes for a $130,000 home along with water and sewer are $442 a month, which is less than the mobile home. Also, the insurance on a mobile home is usually higher than a conventional home due to higher risk to withstand hazards such as hurricanes, tornadoes, floods, and fires. Mobile homes are also at a higher risk for theft and vandalism. And finally, to be considered affordable housing, the units must be affirmatively marketed. Is the developer going to do this? So this project is not inherently beneficial. The municipal land use law was amended to make clear to evaluate whether the proposed use does have a negative impact on the overall zone plan for the community. The relevant provision now reads, "No variance or other relief may be granted under the terms of this section, including a variance or other relief involving an inherently beneficial use, without a showing that such variance or other relief can be granted without substantial detriment to the public good and will not substantially impair the intent and the purpose of the zone plan and zoning ordinance," per NJSA 4055 D70. The intent and purpose of the land use plan is clearly stated in the 2017 land use plan, and this development does not fit or follow the intent. The planner claimed to know the intent of the 2017 plan, but he was not involved or at any of the meetings to develop this plan. His statement was pure conjecture, in that regard slanted to help the developer. Transcripts page 66 and 67. The developer is asking for a use variance and must address the beneficial uses against the statutory negative criteria and prove that on balance and public benefit outweighs any impairment to the zone plan and zoning ordinance or any detriment to the neighborhood. Where the proofs demonstrate that because of specific property's location and characteristics, the detrimental effects of an inherently beneficial use outweigh the public benefit, a zoning board is authorized to deny the requested variance. This should have been done, but was not. D1 use or principal structure variances. The board has the power to grant D1 variances to permit non-permitted uses pursuant to NJSA 4055 D70 in particular cases and for special reasons. This is the so-called positive criteria of a D1 variance. The courts have held that the promotion of the general welfare is the zoning purpose that most clearly amplifies the meaning of special reasons, 1 Medici versus BPR. Our courts have held that certain uses are deemed inherently beneficial, which essentially means that, by definition, the use per se promotes the general welfare. The benefit to the general welfare from a typically non-inherently beneficial use, however, derives not from the use itself, but from the development of a site in the community that it is particularly suited for, the very enterprise proposed. Thus, in a typically non-inherently beneficial use application, the standard the board must employ to determine whether special reasons have been proven is whether the proposed use will promote the general welfare and whether the development of the property is particularly suited for the very use proposed. The special reasons given by the developer, transcripts page 215 and resolution page 13, per section 4055 D2, are G and M. Special reason G states, to provide sufficient space in appropriate locations for a variety of agricultural, residential, recreational, commercial, and industrial uses and open space, both public and private, according to their respective environmental requirements in order to meet the needs of all New Jersey citizens. There are already at least three mobile home parks in Millville: Liberty Village, Holly Village, and Country Meadows. This project will decrease the land available for industrial use and deny the needs of New Jersey citizens for employment. Special reason M states, to encourage coordination of the various public and private procedures and activities shaping land development, with a view of lessening the cost of such development and to the more efficient use of land. Industry projects need city water and sewer service, so this is not a legitimate argument. There is city water and sewer available throughout the city for residential use. The board may not exercise its power to grant a D1 variance otherwise warranted. However, unless the so-called negative criteria has been satisfied, pursuant the last unlettered paragraph of NJSA 4055D7, no variance or other relief may be granted. Without a showing that such variance or other relief can be granted without substantial detriment to the public good and will not substantially impair the intent and purpose of the zone plan and zoning ordinance. Medici versus BPR. Again, this project impairs the intent and purpose of the land use plan. The applicant is also seeking a D5 use variance from the municipality's density restrictions and must also satisfy the positive criteria. The applicant needs to show that the property can accommodate a greater density than what is permitted. D5 density variances. The board has the power to grant D5 variances to permit an increase in the permitted density, which means the permitted number of dwellings per gross acre of land to be developed, pursuant to NJSA 4055 D70. In particular cases and for special reasons, this is the so-called positive criteria of a D5 variance. The general welfare is the zoning purpose that most clearly amplifies the meaning of special reasons. And that benefit to the general welfare from the typical commercial use derives not from the use itself, but from the development of a site in the community that is particularly suited for the very enterprise proposed. See Medici versus BPR. The board's focus should be on whether the site will accommodate the problems associated with the proposed higher density than permitted by ordinance, but permitted use. See Grubbs versus Slothower. The board may not exercise its power to grant a D5 variance otherwise warranted. However, unless the so-called negative criteria has been satisfied, pursuant to the unlettered paragraph of NJSA 4055D-70. No variance or other relief may be granted without a showing that such variance or other relief can be granted without substantial detriment to the public good and will not substantially impair the intent and purpose of the zone plan and zoning ordinance. Again, this development does not follow the intent of the land use plan. This development also is detrimental to the public good. As the Grubbs court held, a D5 variance applicant must, quote, demonstrate that the increase in density would not have a more detrimental effect on the neighborhood than construction of this project in a manner consistent with the zone's density restriction, end quote. The increased density will affect the city's police, fire departments, EMS, and the schools detrimentally. The increased density will also affect the sewer and water departments and drainage in the area. And lastly, the increased density goes against the land use plan. In Medici versus BPR, the court reaffirmed that holding in Cole versus Mayer that if the use for which a variance is sought is not one that inherently serves the public good, the applicant must prove the board must find that use promotes the general welfare. Just an example, normally in considering whether to grant a use variance, boards of adjustments are supposed to weigh the special reasons for the requested variance, also known as the positive criteria, against any substantial detriment to the public good and/or the intent and purpose of the zone plan and zoning ordinance, also known as the negative criteria. A case in Willingboro went all the way to the appellant division and was decided by Judge Skillman. It was agreed that a project for duplexes for the homeless was inherently beneficial. However, the negative criteria of putting duplexes in the midst of single-family homes would cause a substantial detriment to the neighborhood. That detriment was substantial enough to outweigh the positive criteria arising out of this public interest use. So the variance was denied. The developer's own planner stated that the 2017 land use plan was the absolute, but yet he did not follow the intent of that plan. Transcript page 215 to 216. This development is in direct opposition to the intent and vision for the two zones where the mobile home park is proposed. The developer came before the zoning board and did not meet the criteria to obtain a variance. The board did not follow the land use plan, which is what they should have done and have been advised to do. The developer's plan stated that the land use plan takes precedence. Transcript page 216. The developer presented a conceptual plan that was not finalized, and yet the zoning board approved a plan without even knowing all that it entailed. Look at the facts. Look what a variance is supposed to do. Look at the land use plan. Even if this project does not go through, any other developer can put a trailer park in the area now that the variance has been granted unless the governing body does their job and overturns the zoning board's decision. In conclusion, the 2017 land use plan, point number 7 states, utilize data to create land use categories and boundaries that avoid potential use conflicts. This project is in direct conflict with the land use plan. Point number 9 states, present a clear purpose, intent, and vision for each land use category. The land use plan does this. This mobile home park is not part of the vision and intent for this area of the city of Millville. In conclusion, the zoning board erred in granting the variance because they granted the relief without considering the substantial detriment to the public good and without considering the negative impairment to the intent and purpose of Millville's land use plan. This is in direct violation of 4055D-70. The zoning board violated the land use plan. I trust that the city commissioners will look at all of the points made here, backed by law and case, and determine that this variance should not be granted and vote accordingly. Thank you on behalf of myself and Mr. Hewitt.
Thank you. And Mr. Hewitt.
I think it's the turn of the applicant
Legal
to
argument to be given by
offer their
Liberty
argument.
Village. Yep.
Well, let me ask you this. My office was contacted by an attorney that did request a copy of the decision of the board. Is there an attorney here? And do you want to please identify yourself and indicate who you represent?
Sure. My name is Ron Gazarovski. I'm an attorney with offices in Red Bank, New Jersey. I represent the developer of Four Seasons. I have sit and listened to the arguments of both counsel, and I have to say I've been doing this for 50 years. These two
Can't
are
hear
the
you.
best arguments I have ever heard made, whether it be before the appellate
We
court.
can't
Sir,
hear
can you
Can't hear
raise
you,
the
sir.
mic, and also can you
Can't hear
spell
you.
your last name for us, please?
Sure. Gazarovski, Gaziorowski.
And who do you represent? Because that wasn't clear.
If you wait, I'll tell you. I represent Barry Belat, who is the developer of the Four Seasons project. He is a landowner and an interested party in the city of Millville. I have listened to the argument of both counsel. I've been doing this for probably over 50 years. Those are two of the very best arguments that I've ever heard, either before a Superior Court judge, appellate court judge, or a Supreme Court judge. I think they stated the law succinctly. I only wish that I could make as good an argument, and I'm not going to try to do it, but I'm going to adopt their arguments. Thank you.
You're welcome, sir. Thank you.
And I think that would be all of the interested parties, as that term is defined in the statute. And so Mr. Robinson has the floor now.
Thank you, Mr. Solicitor. First, I'd like to pass out to the board for its consumption as part of the response. What I'm passing out to the board were exhibits that were marked and admitted into evidence during the zoning board presentation. Part of the record, they were A1, A5, and A6, as was listed in the table of contents of the transcript.
Thank you, Mr. Robinson.
Of course, thank you. Appreciate, should I wait for the mayor to return?
Wait a couple seconds.
Sure.
Of course, I'll let you the copy.
While we're waiting, can you identify these because they're not marked? Which one is,
Sure, so,
This was from my packet.
that's from your packet?
Yeah, I didn't get that from him. This was from the zoning board secretary.
Are these marked?
Excuse me, Mr. Russell?
I'm addressing Mr. Robinson.
sure. Yeah, I'm just gonna, I stapled them all together, but I can tell you where they cut off. So pages 1 through 24 are A1. That was part of the original record. (26) through 31.
And that is A what?
That was A6
So A6 is pages 26.
to 31. This
Through
is just me
31.
following along with the previous. And then 32 and 33 were A5.
Do you want me to make copies of these?
And so the record is clear. These were actually, or actual exhibits that were introduced into the record on July 1st at the hearing before the Board of Adjustment. Is that correct?
That's correct.
Okay.
These are,
Do you want me to make copies? I can make copies.
I'm sorry.
I can make copies.
Kirk, let me have that back. We'll
I'm
make
gonna make
copies.
copies.
Make copies of these for the commissioners because mine are marked, yours aren't.
while we're waiting, these were documents that were to be circulated as part of the original record. I assume the commission has already seen all of these documents for some time. Solicitor, we're waiting for photocopies, was it?
She's
No, you
working.
may proceed.
Very good. I thank the commission for affording the opportunity for the applicant to be heard tonight. It was a very controversial zoning board application when it was originally presented back in July. In fact, so controversial, it's probably the longest that I had up until that point, where I think we were here until maybe 11 o'clock or something. We can remember 10, 11 o'clock at night. And it was, however things were to turn out, it was really an exercise in civic engagement. I said that at the time. I was happy to see so many interested people coming out and giving their opinion as to this proposal. In going through this very, very, very thorough hearing, I listened carefully and had a copy of what was provided as part of the appeal record here. But I want to make sure that the applicant has the opportunity to really review the truth of what the transcript shows. First and foremost, about slightly less than half of the basis of the appeal is that the zoning board erred in granting a density variance, in entertaining of a density variance. There's 332 lots, and that's outrageous, and how could a density variance like that be granted? In reading from the resolution, and I'm going to confirm this through the transcript, page 14 of the resolution, as was actually resolved by the zoning board that evening. The applicant shall be permitted a D1 use variance to construct a land lease community. The applicant's conceptual plan with 332 residential units is not approved as a site plan, nor is density approved based upon this submission. I think Commissioner Cooper was right. We have mixed messages. This has kind of been a Facebook appeal from the beginning until now. This isn't what happened at the evening. We have the resolution right in front of us. There was no determination as to density. There was no unit count that was decided upon by the board. The zoning board was presented a very narrow question. Is the zoning board comfortable granting a use variance for a land lease residential community in that zone? Split zone, matter of fact. No determination was made as to quarter acre per unit, anything. There's transcript, there's discussion. The zoning board declined to entertain that because, as all of the commissioners have read in the transcript, this was a bifurcated application. Obviously, with such a large development, no zoning board could make any reasonable decision about traffic, about environmental impact, about drainage. None of that could be made reasonably, and nor did the zoning board make it, and nor were they asked to make it by the applicant, because no site plan was part of this application. This was just a conceptual application before the zoning board for the simple question of, are we okay with a residential development on this block and lot? That was it. Everything else has kind of gotten away from everyone. The amount of units, the amount of traffic, and what impact could it have here, what impact could it have there. Cart before the horse. That never was decided by the board. The board expressly declined any decision on that topic. A lot of what we heard in here was about the density and about what impact will this have on the environment, what impact will this have on traffic, water, sewer. All of those are major site plan questions. We didn't even get to a major site plan. That's a formal 6 months from now, full application that would be presented to the board with public notice, distributed to the public. We'd have a full another hearing, and very likely, maybe, maybe not, it would go well or it wouldn't go well for the applicant. We haven't even gotten there yet. So to attack the zoning board, to attack its solicitor, to say they didn't do their jobs by allowing this density, how could they do this? They didn't consider traffic. They didn't consider water management, sewer management. They weren't asked to. That's not what this was about. This was for a very, very narrow discussion of a use variance for a land lease community. I don't want the appeal to move the goalpost. All of a sudden, we're fighting about things that weren't even part of the transcript, that weren't even part of the resolution. Turning to the use variance, I want to make another opening comment after hearing. And this was littered throughout the transcript, and I'm sure the commission has read this. And that's why we have the handouts here that we're going to walk through in a second. Throughout the appellant's arguments, they use the word over and over again, so it'll slowly seep in to the public mindset. Mobile home park, mobile home park. They end with trailer park. It's not what this is. It's very clear. Manufactured home community, and you think, well, that just sounds like fancy lawyer talk. No, that's a statutory definition, the municipal land use law, and they say, oh, their planner lied when he said there's no such thing as mobile home park designations. Well, that's true. We're not asking for a mobile home park. Manufactured home community is not an express designation in any zoning district throughout the entire city of Millville. No matter where it were to go, it would have to end up before the zoning board. So to, hide the ball from the commission and keep mobile home park, trailer park, these are code words. These are buzzwords, that this is beneath the community. This is, I believe one of the quotes in here was that mobile homes are subject to increased crime, increased theft. There are already 3 mobile home parks. Country Meadows, Holly Village, they're asking the commission, they want you to adopt this misconception that that's what this is. I respect the appellants. I understand what's happening here. We all understand what's happening here in October, okay? Mr. Hewitt lives next door to what is proposed to be a residential real estate development. I think we can all be human beings about this. Nobody wants to have development next to their house. You have your house, you have your area, you feel comfortable. Everyone would like to have that type of accommodation, but still have the full weight of the municipality behind them with water, sewer, police, schools, all the good services. I understand what's in the best interest of the appellant. That might not be in the best interest of the city. The city's looking to grow, the city's looking to be creative in its development, and the city's looking to target good opportunities. That's where this developer fit in. Originally meeting with the zoning officer on site, going over the project, and I'm going to now walk you through what this project actually is, so that the commission could have a fair opportunity to not be persuaded by buzzwords, trailer park, mobile home park, high density. Turn the commission's attention to A1. Should have just the Liberty Village right on the outside of it. This was presented thoroughly over the course of the 4 or 5 hour meeting there. So I encourage the board to read through it, so I'll just talk through some of the specifics. First and foremost, I'd like to ask the commission if they would indulge me in turning to page 6. And flip through pages 6 to 15. Mobile home park, trailer park, increased crime, increased theft.
Come get it.
You look through these images, these aren't renderings. These aren't proposals. This is Liberty Village. This is Mr. Carpino's identical development in South Millville as it was taken 3 days before we presented that zoning application before the board. This is what it actually looks like. These are gorgeous pictures of what the property actually looks like. Stick-built garages attached to a manufactured home put on a concrete pad. There's no wheels, there's no lattice, manicured lawns, beautiful sidewalks, improvements, fully taken care of by the developer. Turning through pages 8, 9, you get to 10. Look at the interior pictures of the model home. The appellant wants you to believe that this is some sort of plague that's coming to Millville, that this is a terrible opportunity and would decrease property values or perceptions of Millville, looking at pictures 10, 11, 12, 13 of the interior of the model home. It's gorgeous inside. And this is exactly what it looks like. Like I said, not renderings. And the transcript confirms, I walked Mr. Carpino, who's sitting here to my right, through each one of these slides. And this is exactly what his project looks like in South Millville. This is exactly what his project is being developed and the model home looks like in Buena Borough. This is exactly what Liberty Village 3 would look like. I understand Four Seasons is here, and I understand their objection. Four Seasons located south, further past the airport and past that industrial zone, split zone line that this project bifurcates. Fortune Lane is there. Further north, you have plenty of residential development. to suggest that another residential development community on Cedar Street is somehow out of character, it would impair and frustrate the intent of what's trying to happen in that area, that's disingenuous. We're all here. We all own property here. We all know what Cedar Street looks like, and we all know what developments are there already, and how this would fit in beautifully. We had a real estate expert testify that the demand for this type of housing would be sky high, would be a great opportunity for people looking to find housing in Millville, and they're not finding cheap housing. We see a section dedicated to affordable housing. No, it wasn't presented as affordable housing to the city. This is fair market housing, upwards of $160,000. It's beautiful inside, can be financed. Testimony was given as to financing and what banks were used for Liberty Village 1. We didn't have to speculate, including Millville Savings when Liberty Village 1 was underway. And this would be a beautiful added addition to residential development on Cedar Street. Now, the amount of lots. I have the transcript with me here, so we can see what was actually said the night of the meeting. Starting on page 170, if the commission wants to, I have some sections highlighted I'm going to read, but if the commission would like to follow, but I'm happy to read these here.
What page was that again?
170 of the transcript, Mr. Commissioner. There was some confusion during the public comment from the board and the zoning board that we wanted to make sure we clarified back at the zoning board meeting. The concept plan, may I walk across the room to, I assume it's it's the second court board or third one over there.
You may.
Thank you.
You're welcome.
Yeah, sitting up there.
It's a long walk here. Hold
Mayor, you should bring it to that mic.
These were the engineering renderings of the concept plan. That was, I'll flip it so Cedar Street's on the bottom. That was put before the zoning board. This is where obviously the confusion lies. Concept plan was presented, not for site plan purposes, not saying, look at lots 1, 2, 3, 4, 5. This was a concept layout, roughly, based on it's a large portion. This is 90 acres of land. Roughly, here's an approximate concept of how this would work with a gated entrance, open fields, sports fields, pickleball courts, basketball courts, a community pool, and then a conceptual layout. People see this, they go, oh my goodness, look at the amount of units here. This amount of units exceeds by a landslide any sort of density issue. Well, first and foremost, it doesn't. We did the quick math on it, and even at a quarter acre per lot, but that's not the point. The point is the zoning board rightly asked Mr. Carpino, how did you determine the sizes of those boxes on your concept plan? We don't know. This is a concept. How did you determine? He says, well, he answered, I'll paraphrase, he said, well, there are different models. There's a 1 box, 2 box, 3 box. These are manufactured home terms depending on the size of the potential model that someone could be ordering for him. Page 170, line 21. Mr. Carpino says, we have no idea what the mix will be between 1 box and 2 box. The market will designate what that will be. Line 25, Mr. Carpino, this plan is a conceptual plan, right, with little boxes drawn on it. Unidentified, I by deduction, Mr. Van Emden, is you throughout this whole thing. You're asking questions on behalf of the board. However, the answer is a conceptual, and you're saying the market will determine what you put in it. Mr. Carpino, that's correct. So it's possible the market will predominate with single box units or perhaps with double box units. Yes. What's your experience at Liberty Village 1 in Millville? That everything was 2 box units. Turning to the next page. Professional planner chimes in. Because they're asking how many units we want to understand. The planning answer to your question is, as to this concept plan, in going for a use variance, you would use the highest density, smallest units to determine the total maximum units that you might get at a site plan. He explains to the board, this is not what is actually going to be presented on a site plan. What we're presenting to the board in fairness for the board's determination is if every single person ordered a single box unit, what would it look like potentially? When we go through the site plan, we may not hit that target. We're simply using the smallest unit to aggregate how many there could be. And as Mr. Carpino said, the market is certainly going to dictate that, or site plan approval will certainly dictate that. We're simply setting the upper bar for the use variance portion of the application. Mr. Van Emden says, so the parameters for separation between units, buffering, all these things may, if you get approved for a certain number, that number might still not be achieved because of the mix you're putting. Our planner, our witness says, I'd go further than might. There's no way in heck we'd hit that number. That's on that plan by the time but in all fairness, you're trying to present what conceivably could be Mr. Van Emden says, you might be able to, exactly, it's the speed limit. Everyone harps on, they're gonna build 332. That's not at all what was said at the meeting. Exactly what was said at the meeting is we just put little lines on a piece of paper designated single box units, but that's not at all what history shows is actually going to happen. Nor would it. The site plan would deny it. And I quote, bear with me. I quote the zoning board chair after hearing, and I'm going to go back to explain more of the amount of lots that was not determined. Zoning board chairs, thank you for hearing this. This is page 217. I'm willing to give them a chance to create a site plan that we can look at. I'm certainly not in favor of 332 houses there, but I might be in favor of something smaller there or something different that works into their site plan. I'm at least in favor of going far enough to give them the opportunity to produce the site plan, and I would tend to support that. The determination was made the exact opposite of what the appellants told you. Nobody agreed to 332 units. This was a concept plan that was put together with just boxes on paper showing potentially a theoretical fit. No determination was made, no amount of units was made, nor would one be made until a site plan application would be presented. Now, how would a site plan application be presented? Turning to page 120 of the transcript. Mr. Carpino says, we only have a conceptual right now. And I ask him, and we're going to work collaboratively with the city with the site plan design, Frank. That's correct, he says. So if they say, we'd like an increased buffer, or they say, we'd like this, that's something, I'm using my hands in this moment in time, they'd like this, they'd like that. That's something you're amenable to discussing, most definitely. Zoning board chairman. So if you're going to then discuss the buffer, obviously that's going to take up land. So are you flexible in the number of units then? Because if the city wants a wider buffer that's going to give land, well, yes, absolutely. We're going to have to look at that, Mr. Chairman. And just to be clear, last week I sat with some of the residents, included the appellant, and there were some residents that have concern about the proximity of this project to their homes, and I don't have a problem. We showed 40 feet. If it needs to be increased to 100 feet, the buffers he's referring to. So we're not bothering him, we'll do that. I want to make sure that the commission was clear as to what was actually decided that evening. Everyone ran away with this number of 332 just based off of a concept plan, but all that was decided was whatever the density would possibly allow, also any buffers the city may want, any additional traffic patterns, anything the city may want in a site plan, we're going to work collaboratively with the city to provide that to the professional planner so that we could put together a site plan application still to be heard by the zoning board that would be compliant. So to say it's not compliant, it's over density, and the zoning board was wrong to consider it, it puts the cart way before the horse. We never even got to that discussion. I want to take a moment to talk about our expert witness that evening who's littered throughout the transcript. We presented Craig Rodenkamp as our planning expert. Some of you may know of Craig. Craig was actually one of the authors of the 1990 Millville Master Plan here for the city. He was qualified as an expert before the board, quoted on page 59 of the transcript. I've been in planning field for 39 years. Licensed as a planner in New Jersey for 25. I've served as court-appointed master, qualified in over 100 trials. My history in here in Millville is I worked on your 1990 master plan. Craig gave impassioned testimony explaining that as an author of that plan, and then also one to review the 2017 land use amendment, that this area is particularly suited for the exact use that we're proposing before the board. Water and sewer was ran out. It's otherwise vacant, large area of vacant ground. And it fits perfectly in that half of it is in a zone that permits residential use, and the other is on the borderline for the industrial zone, meaning all the zoning board would have to do for a use variance is move one line over. It's not sticking a residential in the dead middle of an industrial field or something that would be completely inappropriate. The use variance, all the zoning board decided to do was take that yellow line that's over on there and slide it one line over and say, yep, residential can be in that whole area there. No determination as to density. No determination as to anything else. That's all that was decided that evening. I want to go back to the transcript that we talked about mobile home parks, trailer parks. Transcript page 200, fully fleshed out by the zoning board. The zoning board, regardless of how folks feel, if they appreciate or didn't appreciate the final outcome, nobody could say they didn't do their job that night for 5 hours with the room packed. Page 200, line 22. But the municipal land use law has definitions that were adopted in 1983 in a special act that was adopted for manufactured housing. For manufactured housing. A permanent foundation means a system of support installed either partially or entirely below grade, which is capable of transferring all design loads imposed or upon the structure into soil or bedrock without failure. So they have specific regulations, municipal land use law has specific regulations for what a permanent foundation is, and that differentiates between trailers, things that are non-permanent foundations. It's all part of the act and the statute. So people think that these words are interchangeable, and they could just switch it to the board and say, oh, it's gonna be a trailer park, watch out, it's gonna be a trailer park. The pictures you could see with your own eyes, the transcript, this was fleshed out. I understand folks don't want development next to their house. And I understand, that makes all the sense in the world to me. But that's not what this is, and the transcript proves that. We hear the words that are used in the appeal, they're not the same words that are used in the transcript. They're completely different. The purpose to persuade the commission to say, oh goodness gracious, what did the zoning board do that night? The zoning board did its job. And the zoning board was appointed by the city commission and by previous commissions. It's a bipartisan board, and the members on it, I know that. And they engaged in a long, lengthy hearing and came down with a narrow ruling that permitted a residential development in that area. The appellant notes that the special reasons given weren't appropriate. It's not an inherently beneficial use. Attorney here knows, zoning board solicitor knows, that nobody claimed it was an inherently beneficial use. Nobody argued for it to be one. That would obviate the responsibility of the applicant as to the criteria. That's not at all what happened. That's not what's in the transcript. To claim the zoning board and the applicant didn't do their job by presenting an inherently beneficial use is legally incorrect and factually incorrect. That wasn't SALT. That wasn't what this was about. Instead, the focus was on the positive criteria that were noted. They talked about, for positive and negative criteria, will this be a detriment and an impact to the community? I answered to you already. The answer is no. It's already half residential approved, and the other half is right next to it, with multiple residential developments north and south of it, all on the same street, with water and sewer that the city paid great money to run out there for such a reason. And let me find the notation they used. I apologize. was reading this as it was being read to me. They fault the expert planner who helped develop the master plan here in the city for citing special reasons G and M to provide sufficient space and in appropriate locations for a variety of agricultural, residential, recreational, commercial, industrial uses. Special reason M, to encourage coordination of the various public and private procedures and activities shaping land development with a view of lessening the cost of such development and more efficient use of land. That's precisely what was presented to the board that evening. This is an appropriate location for residential use, and this is a lessening the cost of such development for efficient use. You're darn right it is. I agree with the appellant on that topic. Not finding any of the negative criteria and finding that these positive criteria were met, the zoning board ruled in favor of the applicant for the limited purpose of, we're now going to allow you the pleasure of coming back to us in 6 months with a formal site plan where we're going to really beat you up because we want to hear about traffic, we want to hear about sewer, water, we want to hear about school impact, we want to hear everything. We never had that hearing. So to grant an appeal based on a failure of the applicant to note topics it never requested in the first place is just patently unfair. And it's dishonest. That's not what happened. We ask the city commission tonight to have faith in its zoning board. It was appointed. It sat through many expert witnesses, many members of the public. It heard thorough testimony, and it granted only a limited use variance outcome for a land lease residential community on that block and lot, and that was it. Nothing else. It's in black and white on the transcript. Knowing that, we would ask the commission tonight to affirm its zoning board's ruling. Give credit to the zoning board that it did its job, it did it correctly, and it doesn't even mean that this project would be approved. I read to you in the resolution and the words of the chairman who was there that night, this could go down in flames at the site plan meeting. And I suspect, and I'm encouraged by the fact that I think a lot of these folks are going to be sitting at that site plan meeting if we get to that. And that may be the end of it there. But certainly to say that a use variance for a residential development on Cedar Street was out of bounds by the zoning board, in fact, so out of bounds that it should be appealed successfully and thrown out summarily, would be a disservice. So I thank you very much.
Mr. Robinson, I had one question for you about the record. I'm looking at the application that you filed, and it says applicant is seeking to construct 332 homes for a land lease community with solar paneled roofs and is seeking a hearing as to the use variance only. And then when I look at the resolution that was adopted by the Board of Adjustment, it says, whereas the applicant submitted an application seeking D variance approval to construct 332 homes for a land lease community with solar paneled roofs, a D1 variance is sought to permit residential use in the I zone where no residential use is permitted. A D5 variance is sought to permit gross residential density of 3.6 acres per lot where the AC zone requires 5 acres per lot. Isn't what happened, and you can correct me if I'm wrong, didn't your client apply for that upper limit of 332 units and apply for a density variance, but during the course of the hearing, he decided to withdraw his request for approval of a specific number of units, and then that obviated the need for the D5 density variance. So the only variance that the board granted was a use variance. Isn't that a correct statement of what the record shows?
That's a correct statement of what happened. That was withdrawn very early in the proceedings, given the fact that the concept plan was causing such confusion. We abandoned any density calculation and said that would be reserved for the board at a site plan determination. The site plan, if it were to be heard, maybe it only approved 50 lots at a site plan, maybe 25, but that's exactly what happened. It was withdrawn at the meeting. Folks still refer to the application, and folks were in the room, but it was withdrawn. That's exactly what happened.
Hold on,
think
that's
we're
a second. Are there
Yeah.
any questions of commissioners of Mr. Robinson?
lot I want to discuss.
You have a question?
Yeah, you guys have limited time because you've got a meeting coming on at 7, and you might be better off asking questions than hearing a rebuttal, but it's your call what you want to do.
Question, Commissioner.
I'd like to make a comment. 2017 land use. The airport area and the industrial, the I-3 area.
Use your mic.
I'm sorry. Is that about half the property in there that they're looking at? How many acres?
The yellow line, yes, which, just by the eye, bifurcates pretty clearly. One side is the I-3.
It's about
the other's the-
45 acres?
Roughly. If we
Okay.
could go, I could go take a look at exactly, but I think we can all kind of stipulate to the fact that it's roughly half.
With economic development that we're looking to see in the future of the city, our airport is going to be very important to us. We were given in 2017, not an order, but a suggestion to increase. The airport needed to be expanded. So that is in violation, or this decision would be in violation of creating greater development in the airport, something that we feel is a very valuable asset to the city. The other concern that I have is you yourself, to quote you, it said the city paid a great deal of money to get water and sewage out to that area. The question that I have as a commissioner, we look at taxation as a form of revenue. The money that would be potentially raised, again, I realize that you abandoned the 332 homes based on the information that the two appellants provided. If I did my numbers right, concerning those amount of houses, including water and sewage, that would generate $1.5 million of revenue for the city. In this development, that would be nowhere near that. The amount of money that the city would receive based on the amount paid by Liberty Village would be much less. So again, there are issues that we have to consider in the school district. These are not homes that are restricted to people without children, increased police, fire, EMS, et cetera. There's a lot of issues that I don't feel that come across to say that this is better for the city than what the intended use of 2017 suggested for us to do. I hope I'm being clear, but that's kind of one of the things that I wanted to say. Again, there's so much that we discussed.
I do have a-
I'll let somebody else take over, and then I'll come back. if
I
there's
can
any.
help part of that because, I'm the guy with the money, revenue and finance, which really concerns me. And I noticed, because I found this when I was reading the transcript and put some numbers together, we have Liberty Village on South Second Street, for instance. Everybody knows where that is. The city tax coming in is $130,000 is what we receive from that village, $130,000. Of that $130,000 does not stay with us. People have to understand this. A third of that $130,000 that comes in, we owe a third of that to the schools.
That's right. County.
The county comes through, we owe another third of what comes in to the county. So we're lucky to have maybe $30,000, $40,000 just from that. When we're looking at a unit right now being built with 300 homes out there, the revenue coming into the city with their numbers is probably $480,000, if I'm not mistaken, was the number. So out of that $480,000, how much you think is going to stay here in this city? Again, a third of that goes to the county, a third of that goes to the schools. We're lucky to have maybe $50,000 staying here to offset some cost. I have to crunch those particular numbers all the time. The impact that comes into the city. What impact would developments cost the city? The thing is, my feeling, even if they were 300 homes that were beautiful going somewhere else, you never break even with taxes coming into the city on the city services, taxes going to the county, taxes going to the school, and with other concerns that we have. The homes that they're recommending out there and going to build, I would live there in one of them. I'll be quite honest with you. They are beautiful, beautiful residents. I took a ride. I've been at Liberty Village a number of times, back when you used to campaign, knock on doors and things, what you do. But I know families that are there, people who are satisfied with what's happening there. Some people aren't. It's like any other development. You're going to have problems and things that go on. The tax that they charge, the rent that they charge on the land itself that they do, if it's $500, say, dollars a month that you have to come up with to pay that along with your mortgage and all. The problem is the control that they have that they can increase each year, that rent. They can go, I believe, and I'm not a lawyer, check and see if I'm right or wrong, somewhere around 3% they can add on every year to increase the rent of the property. I also took a ride to Perryman's. It's on Pennsylvania Avenue in Vineland. And I rode through there, Perryman's branch. And I looked at the homes. I looked what was happening there. They are beautiful, well-maintained. So I give credit to them. You know, it's just not what and I agree with council. We're looking at trailer parks, and that's what we have a vision of. My impression is they're nice-looking homes that are going to be built there. But I have to be concerned about what impact are 300 homes going to be to our city. First of all, we recognize the wastewater treatment plant. And I know the mayor has been working on this. He's coming up with a great program that we have to invest in a wastewater treatment plant. What impact will 300 homes be in a wastewater treatment plant? Major impact. Right now, you know, we have a little bit of a problem with capacity right now in the wastewater treatment plant. The mayor knows that. We're trying to work on some programs. We have some money coming in from the state on the relief program. We think we can invest some of those dollars into some of those things that are needed in the wastewater treatment plant. But that's just a drop in the bucket with a wastewater treatment plant, folks. We need major renovations in our wastewater treatment plant. We lost a business because we don't have the capacity to handle that. We lost it again. I know Commissioner Dalvis is working extremely hard. We have businesses coming into the city now, and it's happening. It's happening at the airport. It's happening in our industrial park. They'll be using wastewater treatment, water, sewer, what have you. We have to move forward in making that happen, folks, before we undertake to say, well, we're going to put 300 homes out there. There will be an impact, and that's how I'm looking at it. Believe me, I understand, council, you have to go before the zoning board. I understand, you know, you have to have this plan done and traffic safety done, environmental impact studies done. I'm aware of all that. And yes, they would, like any other development. You know, I'm concerned about the environment out there. I'm concerned about the water problems we have out there, the flooding problems we have out there. I don't think I'm telling anybody any different. That what we have are problems that exist in that area right now that the city has to start taking care of. And I know the mayor is working hard with a wastewater treatment plant. We know that a lot of the water pipes that are going here and there throughout the community, we have to do that also. That's where I look at it as a revenue and finance person. Do we make money? You do not make money, folks, with housing. It's an impact with our schools. We had a letter from the school board in opposition to it, from the vice president of the school board. They're concerned the impact that it will be in our education system. Already, the budget from last year was a 4-cent tax increase in your school tax, because we have to provide those dollars for education. And I don't have a problem with that. I will pay that. I'm pro-education, you know, but it's an impact. So I always look at things, what impact is it going to be in the city financially? So there's still a lot of work that has to be done before we go out there and start overused our wastewater treatment plant. We have businesses that are coming in right now. I'd rather have more businesses out there than I would a housing development, because you do not even break even with housing. I'm not opposed to their homes. I think they're beautiful. I don't have no problem with it. You know, I would live there. I think it's great because, you know, those of us who are older folk look to downsize. You know, we get a little place, I'm not that old, but we get a place to live. You know, I don't have to mow the yard. I don't have to do all the things that have to be done, even though you still would have to mow the yard out there. But, you know, that's how I look at it, folks. That's why I'm very concerned about where we are with housing coming into the city. If it comes in too quick, are we going to be able to meet that demand with a wastewater treatment plant? Are we going to meet that demand on the infrastructure of our city? We have to clean up that area, first of all, because it's flooded all the time. Anybody live out there? Okay? You know, I'm not telling you any stories. You know what it's like out there. So we have to address that. And what are we doing now? We're going to put 300 more homes out there that's going to create more water runoff. So, you know, I'm not opposed to, you keep, and I agree, you know, it's not a typical, you know, park like people think it is. They're beautiful places. They're beautiful homes that they're making a recommendation and bringing there. But I have to look at it on the revenue side. What's it going to cost the city? What's it going to cost the city now? You know, so that's my feeling, and I think Commissioner Pepitone, you're absolutely right. I mean, I crunched those numbers, you know, and if we will derive, if there's 30, say 300 homes, well, let's see, that might be $482,000 coming into the city. And as I repeat, only a third of that will stay here in this city. A third goes to the county, a third goes to your schools. We have to have fire, we have to have police, we have to have rescue, and education. So are we getting the big bang for our buck? The answer to me is no. No. That's how I look at it. So, you know, I'm sorry, but I get a little lengthy. I can talk a little bit now, sometimes a little rough, but I'm okay.
Thank you,
All
Vice
right.
Mayor.
Thanks, Mayor.
Mr. Mayor, Mr. Robinson, I do have several questions, and before we do begin, I'd like to also, please feel free to step up to the podium. One of the items that I would like to mention is that having thoroughly and extensively reviewed not only the sequence of the transcripts, but all of the details that were contained within, I would also like to mention that on behalf of the Board of Commissioners, that our job as part of the de novo hearing is to hear this as a first time and provide our own interpretations of it. And I know that there have been several references to definitions, to the fiscal elements of it, and realistically, we're here today to examine the land use part of it, where this actually pertains to the D variance. In reading through the very extensive application and the hearing that evening, I'd also like to extend to Chairman Worthington and our board solicitor, Mr. Van Emden, who are here this evening, that I do feel that you carried out your role and that you examined the process. We all have different interpretations from land use, as we heard that evening, also from testimonies of the board. So I would also like to mention that in some of the sentiments that I've just heard in the undertones, that I was also explained by our city solicitor very frankly, very earnestly, that we're here to look at the land use element part of it. We're here to look at that part of the application and to re-examine it anew, and not to critique in any way, shape, or form any of the decisions that were made, but rather to use the evidence to form our own opinions. So I would like to state that, because I think that it should be stated on the record formally, that it's not a matter of choosing sides, but rather utilizing the information that we have to create our own decisions independently. And with that, I do have a few questions that I would like to direct toward you now, Mr. Robinson. In regard to, and I know that fiscally, irrelevant data as stated by the record, and this was included in one of the records, I believe that it was on page 77, that a fiscal presentation is in fact not relevant to the land use element part of it, which is one of the items that I was reviewing the application in its entirety stood out to me as being a prominent factor. The fact that they're manufactured homes, in order to be exempt from property taxes under state law, I only ask on the grounds of definition. In regard to, as the application is presented, that the land use is based on the existing Liberty Village, and only on that definition alone, is an exemption from property taxes in effect to in fact allow this to fall under the definition of a manufactured home being deemed part of a mobile home park, or being being categorized as such.
Commissioner, I'm not sure as to the last few words, but the first,
Yes.
the thrust of your question is, yes. A6 that was provided to the board, we're going to talk about the financial impact, is an explanation. This board some time ago, I think dating back to Liberty Village 1, as a matter of fact, discovered that homes that were titled and not deeded were exempt from calculation as an improvement upon the land for property taxes. Back when the city instituted Section 65-34 municipal ordinance for a service fee to be collected, a flat fee per year. Good news about this flat fee is that 100% goes to the city, nothing to the county. So that was wisely done by the city commission back when. So any manufactured home, the home itself that was craned and put on a foundation, while that specific home is exempt from property taxes, it's charged the annual service fee for property, for an assessment of 100% to the city. So that's component A on the first page of A6 here. Now, component B is all of these homes are going to have stick-built additions to them, full garages. Those are total improvements. Those are taxable improvements, real property tax dollars. There's no exemption, and I think I've seen, out and about with abatements and things. None of that exists. That's not the reality whatsoever. So what the city would consider is you would multiply the amount of units, and maybe it turns into 50, maybe it's 100, maybe it's, whatever it may be, by the service fee that the ordinance has for each of the units themselves, plus the real property taxes from the stick-built additions, plus the real property taxes from the improvements of the entire parcel itself, which, as I described, has a full community house that's going to be put on it, basketball courts, pickleball courts. The improvements themselves, we did calculations and had conversations, not to run into a hearsay issue here, but as was put in the transcript, we had full conversations with the tax assessor. Mr. Tax Assessor, would you agree that the rubric you use for Liberty Village 1, would that be an appropriate rubric to use for Liberty Village 3? He said absolutely yes. So with that on A6, I did the calculations of multiplying out these service fees plus the improvements based on the same rate as Liberty Village 1 multiplied out, and that's where we got the $482,000. But the division, as I mentioned, 100% of the service fees go to the city.
And
only the real property taxes get divided up, as the Vice Mayor mentioned, yes.
Thank you, Mr. Robinson. And I ask for the sake of the definition and not rather for the actual amount in and of itself. With this being realized and with the concept of this being factored into, under the definition, a manufactured home being exempt under the definition of a mobile home park, one of the items that I would like to ask next is it true that the 2017 land use elements classifies mobile home parks as a multifamily residential use under definition as included on page 47? And would this therefore eliminate the proposed use variance from being accepted as medium density as provided under the land use plan element?
And I apologize, that's the nature of the question. I don't, you said as by definition, the mobile home park. It switched from manufactured to mobile. And what definition? What switched it?
In terms of if this were to follow under the previously approved and now in effect Liberty Village, if it is
Sure.
in effect being exempt from certain property taxes, because I know you mentioned the stick-built structures, but realistically, those would be accessory structures. So they would not really constitute under definition. If I were to interpret this as being medium density or single-family detached homes, as they're not in that point being included in the definition, which is one of the items that just under definition, as I'm looking at this purely from land use,
Right.
is one of the items that I time and time again had to look through the transcript
Sure.
and eliminate that information that I felt was brought into the discussion, but did not fully explain
I
the
agree,
context for the land
A large
use.
portion of the hearing was a curiosity exercise as opposed to a land use for some of the questions we were receiving, and we wanted to be prepared.
And
But I
even this
understand your
evening,
point. Yes.
we're hearing different references to what is the benefit versus the negative, the negative criteria, the positive criteria. In my opinion, the concept of that being proven is also contingent upon the definition being fully fulfilled and realized in the fact that if we have these primary structures and in a medium density zone, we are proving them to be single family detached homes, but in effect, these manufactured homes in their community are constituting a definition that would then be deemed multifamily residential use to be included with a zone that is either a standalone or one that is included in a previously approved and constructed area, that is the area in which I'm looking at that as being my burden as a commissioner, but also in having to serve in the role as examining this from land use perspective only, is that I find that the discrepancy in the definition is what very clearly makes this a case of not necessarily looking at the fiscal positives, but rather how does the fiscal aspect of it promote what the definition is, and how does the definition now not fit into the zone?
Sure. I apologize, Madam Commissioner. I'm not sure if I adopt the definition switch. And multifamily home, these aren't comprised of multiple units. There is a discussion as to what the density requirements would or wouldn't be. The transcript actually fleshed out where the planner mentioned a land lease community might be a singular use in its own right and not a density calculation of lot, because if you remember, these aren't going to be subdivided. So how can we do a density calculation of lot? So I'm not sure if I agree or adopt with that definition, but frankly, this is all the more reason to allow the applicant the opportunity to have a formal site plan where we can have these things fleshed out, number of units, and then we can have a density calculation. We're getting caught up with 300 units, and how much is it going to cost?
And all density items aside, that was in fact where I noticed that it was the way that it was explained in terms of the property taxes. If it's seeking a definition and an eligibility under that criteria,
Sure.
then where does that lead us to with the actual definition of the area in and of itself? One of the other items that I did note was the concept of it being peculiarly fitted, and how the site that's located on the north side of Cedar Street is distinguished as being particularly suited to this particular use versus other areas that could be in contiguous areas that have already been approved, similar to Liberty Village in previous
The
developments.
zoning board wasn't tasked with determining what other possible sites could also be particularly suited. This one in particular, just by nature of its topography, good ground, of the transcript confirmed forestry with an inability to actively farm on it, water sewer, large development to the south of it, large development to the north of it. It's settled in a place where it's tough to say that this isn't an appropriate location for this. It's a great location for this. And if there's other concerns, what about schools, what about money? I mean, it sounds to me like they would exist anywhere, and wherever we put this, that neighbor would show up and have a problem with it, and I understand that too.
Right.
So I think the zoning board was tasked with evaluating the particular location that was presented to it, and based on the testimony given and the factors I just mentioned, became determined that that was met, and that this site is particularly suited for this type of residential development.
And if I may, and this is also in tandem with a comment, that through having reviewed the transcript and having ultimately, when as it was described on the actual agenda as being a C bulk variance, had been bifurcated from the application, and the land use was, in fact, the main focus, I did recall at one point during the transcript reading the city solicitor stating that at this point we are examining the concept of the land use. As one who was reading the transcript and examining it, and then also taking into account that a lot of the information that was included in the transcript regarding fiscal plans, regarding projections, that all of those items aside, that the land use without the conditional, if we provide this, then we will grant this approval. With all of that aside, and having in fact taken into account the land use plan element, that was at that moment for myself as someone who was examining the plan, when I realized that if there had to be conditions that were provided in addition to that, that perhaps if my vote were to have been cast that night, that ultimately the land use didn't afford the opportunity to explore that option. That's merely my interpretation, as I know there were many different interpretations that were expressed that evening through the transcript. But in closing with that comment and with that remark, Mr. Mayor, that's the conclusion of my interpretation and comments this evening.
Thank you, Commissioner. Commissioner Cooper.
Thank you, Mr. Mayor. So we understand that there are many issues surrounding this variance. However, if you will indulge me for just a moment. Being a former school board member, I'm really interested in the school impact, and we didn't really I don't think we went really into that. If you can go a little bit more into that.
Absolutely, this was
And if
part
there,
of.
and if
Sorry.
Ms. Malone, would you like to speak to that as well? If anyone here from the school would like to, would they be able to do that, Counselor?
Oh, I'll.
Well, it's not a regular public hearing, that's the
Okay.
problem, and you allow one person to speak, then you have to let everybody speak, and I don't think that this type of application is that kind of a hearing.
Okay.
Thank you.
Counselor, thank you.
Commissioner, to your questions, I turn the commission's attention to item A5 that was submitted. So Commissioner Davis's point was well taken, is that while we didn't know if it would be germane necessary to the use variance approval, we wanted to be prepared, and we understood the nature of some concerns. And I, obviously, I want to disclose I represent the school board. So, and the school board is aware of that, and we discussed that, and I've been kind of purposefully kind of left out of the school board's letters and such.
Which
I've
is
not
why I
co-authored-
asked you,
I have
right.
not gotten involved in any of that, and Arnold Robinson's not gotten involved in any of that. So, what was presented that night, and then I can speak to that. The planner, in the transcript, advised that part of his professional capacity is also to do school evaluations. That's part of his planning responsibility. So we prepared A5 that he authored, noting that in 2011, Millville school enrollment was 6,200, 2020 was 5,100. A lot of folks were really concerned, saying, oh my goodness, 300 units, you know, the kids are going to be falling out of the windows getting into our schools. Two things I want to bring to the board's attention. One, this project, as was said multiple times throughout the transcript, obviously not 300 units, that was never determined in this concept plan, but whatever the units are going to be phased. This is going to be a 10-year at least build-out. And they get sold, he doesn't just buy 300 manufactured homes and hope it works out for him, much like Four Seasons. Four Seasons got granted for 600. They're only up to maybe, 200 right now at most, 150. So as a home gets, you get a buyer, somebody comes in, it gets sold. Mr. Carpino's been in this industry for quite some time, principal planner testifying that the average is 0.5 children per one of these homes, as a result of these homes being targeted for senior citizens, for empty nesters, for second vacation homes. So it's less children. So if 300, 200, 100 units were to ultimately get approved, and it's a 10-year build-out with 10% each year, it's 10, 20, 30 kids a year for a school that just lost 1,000 kids in the last 10 years. Now, this was information I purposefully didn't want to talk to my school board. The school board asked amongst themselves to form a committee to meet with the developer ultimately, which is still slated to happen to the extent we get to a site plan. And that's when they're kind of waiting for that to happen so we could discuss these issues. But number one was capacity. There's not going to be any capacity issue whatsoever. That is, I'll say, mischaracterized politely as something that people could be really concerned about with this project. There's not going to be any impact on the schools as to population. Number two, the planner testified, given our unique nature of where we're located, sources of funding and such, only 10% of the cost of students in Millville is covered by the city. 90% covered by state and federal funding. So as a result of those calculations, it's not to think, well, okay, so you have, 20, 30 kids a year, how much is that going to cost us? Well, it's going to cost 10% of the total amount. Calculated on the record that evening is $685 a year per student, multiplied by 20, something like that. You know what I mean? If we kind of go through that math, we're talking, 20 grand, 30 grand, something like that a year, to really say we don't want families. We think this should be age restricted. We think that's going to be the problem with this whole thing. That's not borne out in the data. That's not borne out in the facts. This isn't going to cost an arm and a leg and to disincentivize families that maybe would be best suited in that area based on price point, based on composition. I'm answering your question, sir.
He's got the floor.
Yeah. So as a result of that, $685 a year for each student to enter the district isn't a big issue, respectfully speaking. And I realize money's money, it's important. And I put directly underneath of it because of the pad fee, because of the service fee, because of the property tax generated. Millville will get 100% to keep $1,150 a year per unit. And at half a kid per unit, you do the math, there's no financial burden on the school district whatsoever. There's no capacity burden on the school district whatsoever. But I understand the reservation of the school district, of citizens. I understand that folks want answers to these questions. We provided the answers. They're in the transcript. They were here in black and white. They were presented that evening. But, the train's on the tracks. And this is the thing that folks are concerned about. I get that, but that's the data, Mr. Commissioner, as to that question.
Thank you.
No other questions?
No.
Can I have
Go ahead. Go ahead, Commissioner.
Use the mic. Thank you.
You talked about taxation on the stick-built garages. That's not the same cost of a house, number one. Number two, school costs are being more and more transferred to the cities. I'm glad we have a couple school board members here right now. I see any new home that comes in, whether they have children or not, help offset the cost of schooling, because a lot of people have had school children. When I have 5 children in the school system, and I'm paying X amount of taxes, and someone has no children, the money's spread out among all of us. And as we build these new homes that we can get tax dollars for to help our school district, that's very important. The other point that you made is the monies that we get from this project is going to go to the city. Our taxpayers not only have to pay taxes to the city, they still have to pay those taxes for the school as well as the county. So my point is we really need to have taxation based on the entire value of the property.
Thank you, Commissioner. Anyone else? That's it.
Thank you.
Are they allowed to come
I'm sorry, with
up?
that.
Mr. Hewitt and Ms. Orndorff.
Well,
Unless we have any other questions? I don't
Chair, you're going to have to decide whether you're going to allow that. That's discretionary, and we do have another meeting that starts
Thank you,
at 7
sir.
o'clock.
Thank you.
Yeah.
So, thank you, Mr. Robinson, and we will not hear anything else. Thank you. You may sit down. I want to thank Mr. Hewitt and Ms. Orndorff for coming up. I also like to thank Liberty Village for being here and their attorney. And there's an executive summary of the city solicitor here. So, Brock, we'll go right into you, sir.
Yeah. I think the starting point, if you're analyzing a D variance, is this book, and it's Professor Cox's treatise on New Jersey zoning and land use administration. Every board solicitor has this book, and a lot of board members do too. And this is really the Bible. And when you look at the section that deals with use variances, and it's at chapter 32-4, it talks about a site suitability test, and it says merely demonstrating that a particular use promotes one of the purposes of zoning listed at NJSA 40:55D-2 is not enough to satisfy the positive criteria. It also must be shown that the site is peculiarly fitted or particularly suitable for the proposed use. In the context of the positive criteria, site suitability is not concerned with ordinance zoning criteria, but is instead focused on, one, why the location of the site within the municipality is particularly suited to the use despite the zoning, and or two, what unique characteristics of the site make it particularly appropriate for the proposed use rather than a permitted use. So in this particular case, I think you're going to need to decide, did Liberty Village establish at the hearing on July 1st that the proposed location, this area that's on the north side of Cedar Road, is one that's peculiarly fitted or particularly suitable to a mobile home park, or if you want to call it a manufactured home park, as opposed to any of the uses that are permitted in either the I-3 zone, like, for example, an industrial use, or in the AC zone, and the land use element recommends that that be rezoned as medium-density housing. So let's take that. Does it make it, is there something about this site that makes it more suited to a mobile home park or a manufactured home park than a medium-density housing developed? So that's question one. The second question is the negative criteria. And under the Medici case, which is a Supreme Court case from 1987, that case held that when you're asking for a use variance, an applicant must also establish with an enhanced quality of proof what is known as the negative criteria, and that is that the variance sought is not inconsistent with the intent and purpose of the master plan and the zoning ordinance. And Medici has language that says that the applicant's proofs and the board's finding must reconcile the proposed use variance with the zoning ordinance's omission of the use from those permitted in the zoning district. So you really have to kind of explain why the governing body neglected to make a mobile home park or a manufactured housing park a permitted use in the zone. So that would be the negative criteria. Now, one other comment that I would make is, you know, I guess this particular application was described as a mobile home park, and then the applicant disagrees with that and describes it as a lend-lease manufactured home community. Ordinance Section 6530 at SEC exempts manufactured homes from property tax only if they're located in a mobile home park. So to me, I think the zone that it would have to be in as a permitted use would be a mobile home park. By the way, that's not just our ordinance. There's also a state statute, which is NJSA 54:4-1.5, and it talks about when manufactured homes are not subject to taxation as real property, and it's only when they're located in a mobile home park. So, you know, that's what the ordinance says, that's what the law says.
Thank you.
Anything else, Solicitor?
I have nothing else.
Thank you. So, Madam Clerk, there's a motion on the floor.
No, actually, if somebody wants to make a motion on the floor, this would be the
Okay.
time to do that.
So I was turning it over to you.
Not my motion.
You have a motion on the floor?
Motion on the floor, yeah.
Motion has to be said, correct?
Okay.
The way it should be phrased, and again, I like positive motions. I don't like negative
Right.
motions. I'm sorry, Vice Mayor. But this is an application to reverse the decision of the zoning board of adjustment. But I think you should phrase the motion as a motion to affirm the board of adjustment. I think that makes it clear. And a yes vote would be yes, affirm what the board of adjustment did. A no vote would be no, to overturn the board of adjustment and deny the variance. Now, if you'd rather phrase it the other way, you can, but we'll probably confuse the heck out of
So a no
everybody.
vote would deny the variance.
Right.
I think
Can we
that's-
go with what
You
you
would
just
rather
said?
have the motion to deny the variance?
No, he said what, he would
Motion
just
made to
explain what
affirm.
you said.
Okay, a motion to, what we're doing is, we're either affirming the Board of Adjustment or we're reversing the Board of Adjustment. That's really what we're doing. Okay, if we affirm the Board of Adjustment, then we agree that they're entitled to a use variance. If we reverse the Board of Adjustment, then we disagree and we set aside the use variance.
So the motion would be to disagree with the Board of Adjustments.
No, he said the
That
opposite.
would be a no.
Should I make,
You can make that motion if you want.
that would be your vote.
Okay.
Can I make the motion? Tell me if I'm on point. I'd like to make a motion, or the motion on the floor is that of affirming the decision of the planning board,
Zoning
The
board.
zoning board.
the zoning
Yes.
board, I'm sorry.
So yes would be, yes, I want to affirm
We
what
need-
the
we need
Board
a
of
second.
Adjustment did. No would be, no, I want to reverse what they did.
Well, what we're saying is we're going to reverse the decision of the of the zoning board.
By voting no.
No.
So I need a second.
We either affirm or we reverse, and his motion is to affirm. So again, a yes vote would be yes, I want to affirm. A no vote would be no, I want to reverse it.
So you want to reverse it, so you have to
Yep.
vote no to
Right.
reverse it.
But I
So
need a
Second
I
the
need a
motion,
second.
Jeannie.
Hold on a second,
No is you want to reverse it.
Vote no. Fair.
Yeah. You want, all right.
Com-
I want to make sure.
I think it's clear.
There
Commissioner
is
Pepton.
no motion now. The alternative way you could do it, nobody, well, actually, the.
No, he made a
The
motion,
way you said
He's-
it.
he-
We need a
He
second.
did make a motion.
but there
got
was
it,
not a
and vote
second.
no.
I second it.
Bruce seconded it.
I second the motion.
Oh, Vice Mayor, Bruce did it
Bruce
already.
seconded it.
Bruce seconded.
Bruce seconded it.
Yes.
So the motion is no is what they want, no vote.
Why don't we do this? Why don't
That's
we
the bottom
vote on
line.
his motion? And if the board declines to affirm the Board of Adjustment, then someone can make another motion to reverse the action taken. Then the record
Why-
will be
why?
completely clear.
Why would we do two motions?
Exactly.
Well, then you probably need to frame it as, you need to rescind his motion, then it probably should be a motion to, based upon what the vice mayor's intent is, I think it would be a motion
Intent is
to
vote no.
deny the variance.
Decision-
We already have a motion on the
intent
floor.
is
We
the-
Matt-
have to vote on that.
Let, Mr. Solicitor, please, let him talk so that we can all listen and hear, so he could be clear, so that we all can understand.
What I would prefer that you do would be, because your choice is to affirm, to
Right.
reverse, or you could remand back to the board. There's actually a third choice. So if you, his motion would be to affirm the decision of the Board of Adjustment. Why don't you vote on that? Then I'll decide if a supplemental resolution is necessary. Can we do that?
May I just clarify, Madam Clerk, the motion that Commissioner Pepitone made that was written down, would you please read that back to all of us
Right.
and to the public?
Yeah, so Commissioner Pepitone made a motion to affirm the decision of the Zoning Board of Adjustment.
Thank you.
You're welcome.
That's affirming what they.
And it was seconded by Commissioner Cooper. So there's a motion and a second on the floor. We really need a roll call on that. Unless
Yes.
somebody
Roll
says
call.
it.
So we're going to say no.
Commissioner Pepitone.
No.
Vice Mayor Parent.
No.
Commissioner Udalvis.
No.
Commissioner Cooper.
No.
Mayor Santiago.
I'm going to say no, but I want to thank the solicitor for really giving
Motion
us the
carries.
information that was really needed at the end, that was very, very important, so thank you, sir.
Now, I think so the record is clear, because this could go into litigation.
Absolutely.
I would suggest that someone make a motion to deny the use variance.
Make
I'd
a
like to
motion to
make-
deny use variance.
Second the motion?
Roll
Okay,
call,
so
please.
Hold on one second. So Commissioner Cooper made a motion to deny the use variance granted by the Zoning Board of Adjustment. Okay, and then the second came from Commissioner Pepitone.
Yes.
Roll call.
Roll call.
Commissioner Pepitone.
Yes.
Vice Mayor Parent.
Saying no. Yes.
Commissioner Udalvis.
Yes.
Commissioner Cooper.
Yes.
And Mayor Santiago.
Yes.
Okay, motion carries.
Thank you all for coming out.
Can we have a motion to adjourn?
So moved.
Second?
All in favor?
Aye.